Baiju Ravindran has lost immediate operational control of his edtech startup BYJU'S following the admission of an insolvency petition against it by the BCCI months after key investors sought to oust him from the company he founded. On July 16, the National Company Law Tribunal admitted BYJU'S parent, Think and Learn, to the insolvency resolution process. The BCCI had dragged the former sponsorship partner of the Indian cricket team to the bankruptcy court for allegedly defaulting on dues worth 158 crore rupees. So what does this mean for BYJU'S management? BYJU'S will no longer run by its earlier management, which was led by its founder Baiju Ravindran. The day-to-day affairs of the company will vest with Pankaj Srivastava, appointed as the interim resolution professional till the lenders hold a meeting to form a committee of creditors. Once the COC is formed, it can choose to replace the IRP. The IRP will then be responsible for the affairs of the company and will also report to the NCLT from time to time on the progress. Meanwhile, the COC will have to come up with a plan to revive the company or sell it to an entity that will run it and return their dues over a period of time. This is called the resolution plan. According to the IBC, a resolution process must be completed in 180 days and the NCLT has the powers to extend the period to a maximum of 330 days. If there is no resolution to a company's insolvency even at the end of 330 days, the NCLT has to order liquidation of the company. What happens to the current employees? The COC will take a call on the company's existing workforce depending on how they want to run the company over the next 330 days. The COC in its commercial wisdom may choose to retain all current employees or terminate their services, depending on how they want to run the company. The employee's fate is dependent on the current revenues and reserves available with the company. What happens to the tax dues of BYJU'S? On the day BYJU'S was admitted to the insolvency resolution process, Moneycontrol reported that its current and former employees were in for an unwelcome surprise while filing their income tax returns, as the company had allegedly not remitted the tax deducted at source to the government since as early as June last year. This makes the company liable to pay the TDS dues to the government. However, the larger question here is, will the erstwhile management face action for this? Or will the resolution professional NCOC, which is now in charge of the company's affairs, be made to pay the same?